Assalamualaikum warahmatullahi wabarakatuh. We are from Group 8 and my name is Muhammad Adli bin AZMAN, metric number 2313043.
My name is Muhammad HAZIM MANSOR, metric number 2316073. And my name is IRFAN KAMALUDDIN, metric number 2314163.
And we are going to present you guys about the law of torts negligence. First of all, we would like to apologize to Madam and to our tutorial mates for delaying our presentation. Um, we hope that you guys can watch our videos in your free time. Free time. Okay. Without further ado, let's move on to the presentation. Uh, For the facts of the scenario, Shan was a final year medical student warded in Cedros Hospital for a few weeks due to severe breathing difficulties. He was heavily dependent on an oxygenator for oxygen supply to his body. None of the doctors or nurses liked him as he was arrogant and often shouted at them as he thought he knew more than them. One day, Shan instructed Nurse Dell to give him 1 millimeter of morphine for his pain was unbearable. He was insisting so much and hurling abusive words at her. As she could not get to the attending doctor, she just administered the morphine to Shan. A while later, Shan needed to go to the toilet. He removed the oxygen tube and went around 3 minutes later. His oxygen, his oxygen reduced and he fainted in the toilet. This, this, this was also due to the fact that he was drowsy due to the morphine. When Nestle came in and found him not in bed, she panicked and hit the code blue button, resulting in the whole hospital resonating in a loud alarm. Dr. Olix rushed to the room and saw Shan barely able to breathe. They dragged Shan, put him on the bed, and just as they were going to restore the oxygenator, a very bad thunderbolt hit and electricity went off. As the oxygenator depended on electricity to work, Shan suffered brain damage as Dr. Alex was struggling to fix the oxygenator to the generator. Meanwhile, the sound of the code blue alarm shocked another patient, Mr. Hausen, and he helped Minah, the nurse who was at his bedside, attending to him at that material time. As he was always disturbing and harassing the nurses, Minah punched him. He fell and broke his pelvic bone. So from the facts of the scenario, um, we can we can show that there are three relevant parties, which is Shan and Nesdel. Shan against Dr. Olix and Mr. Hausen against Nesmina. Without further ado, let's move on to the first relevant parties, which is Shan and Nesdel. The legal issues diagnosed or we discovered in Shan and against Nestle is whether Nestle's administration of morphine without proper authorization constitute negligence, and whether the administration of morphine to Shan was a contributory negligence. So moving on, the first issue, whether Nestle's administration of morphine without proper authorization constitute negligence. To prove negligence, we need to establish three elements, which is duty of care, breach of duty, and causation. First, we need to prove the duty of care. We can use two types of tests to establish duty of care towards the defendant, which is the neighbor principle and the caparo test. Since Nestle and Shan have a special relationship between nurse and patient, we can presume that neighbor principle can be used in this case, as it was a close proximity between them. In the case of Fu Fiona and against Dr. Su Fok Moon, the learned judge said without the doctor and patient relationship, there is no duty on the part of the doctor to diagnose, advise, and treat his patient. This means that doctor and patient relationship or nurse and patient relationship automatically has a duty of care towards the patient. In the famous case, which is Donoghue and Stevenson, the rule that you are to love your neighbor becomes a law. You must not injure your neighbor. And the lawyer's question, who is my neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Okay. Moving on to the second elements of negligence, which is breach of duty. To establish the breach of duty, we need to see the standard of duty of care for professional. Three elements were need to establish the standard of duty of care, which is professional standard, error of judgment, and which professional standard. So in this situation, we can highlight the standard of care for a nurse. What is the standard of care for a nurse? According to the Nursing Board Malaysia First Edition 1988, 1.2.1, the nurse is expected to provide a good standard of nursing care in the following manner. Conscientiously assesses the physical, psychosocial, and spiritual needs of each patient, provide compassionate and competent nursing care to meet each patient's need, intervenes appropriately and promptly to prevent complication. In the case of Chin Kiao and Government of Malaysia and another, an amah, which is the deceased father or mother, died in 1 hour after she was given a penicillin injection at a clinic. The Privy Council overturned the decision of the Federal Court and agreed with the High Court that the Doctors Act was below the standard of care and had been negligent, as it was expressly written on the patient's card that she was allergic to penicillin, yet the doctor did not check it first before giving the injection. If the doctor act differently, the amah may still be alive. So we can see that the injection of penicillin given by the doctor to the plaintiff was below the standard of care because he had been negligent by it was because of it was expressly written on the patient's card that she was allergic to penicillin, but the doctor gave it anyway. Moving on to the third elements of negligence, which is causation. Causation in fact and causation in law. Causation in fact, whether or not the defendant's conduct has in fact caused the damage to the plaintiff. We can use the but-for test, which is would the plaintiff on the balance of probabilities have suffered the injury or damage. In the case of James Kenneth Ng Siu Goh and Lee Kim Hong, the deceased had suffered palpitation and the doctor prescribed Locadrin to him, and not long after that, she suffered breathing difficulties which led to her death. The defendant denied liability on the ground that he did not cause her death. The court decided that the defendant was held liable as it was later proved that the drugs, Locadrin, specifically led to her death. So we can see here in this case that the defendant's conduct would have caused the suffer an injury to the plaintiff. So the causation in fact was established there. So the second one, which is causation in law, whether or not it is reasonably foreseeable that the defendant's conduct will result in the damage or injury to the plaintiff. In causation in law, there must be no intervention between defendant's breach and plaintiff's damage. There are three tests that the causation in law needs to prove in order to establish the causation in law to the defendant, which is the direct consequences test, reasonable foresight test, and novus actus interveniens. The highlight one is novus actus interveniens, which is there should be no intervention which breaks the chain of causation, which is the causal link between the defendant's breach and plaintiff's damage. In the case of McHugh and Holland and Hannon and Kubitz, plaintiff suffered injuries due to the defendant's negligence. While plaintiff was in recovery, plaintiff descended a steep flight of steps and injured his other leg. Plaintiff sued defendant for negligence, and the court decided to refuse the plaintiff's claim of right leg's injury. The court said that it was his own action that he injured his right leg, not the defendant. So it means that the injury on the right leg of the plaintiff was not caused by the defendant. So there was no causation in law, as it was reasonably unforeseeable that the plaintiff would descended a steep flight of steps and suddenly injured his other leg. Okay, moving on to the application of the duty of care. By applying the neighbor principle, we can already assume that Shan and Nestle have a special relationship between them, which is a nurse and patient relationship. In order to use the neighbor principle, we need to prove that the defendant's conduct would adversely affect the plaintiff, subsequently injure the plaintiff. Nesdel's conduct of administrating the morphine to Shan is a conduct that would affect him, making him drowsy and eventually fainted in the toilet without anybody monitoring him. This shows that Nesdel had a duty of care towards her patient, especially Shan, who got drowsy after the morphine effects and went to the toilet without monitor. So we can see here that Nesdel, even though Nesdel had a duty of care to Shan, as they was in a special relationship, Nesdel's conduct of administrating the morphine to Shan is a conduct that will breach a duty of care to Shan because of the morphine, Shan had a suffered drowsiness and eventually fainted in the toilet. The second application, the breach of duty, we need to digest the standard of care for nurses in order to prove Nestle negligent. By looking at the standard of care for nurses by Nursing Board Malaysia First Edition 1998, the provision stated that a nurse needs to intervene appropriately and promptly to prevent complications. By administering 1 millimeter of morphine to Shan while she was sick does fall below the standard of care for nurses. Nesdel's conduct falls below the standard of care for a nurse to a patient as she ought to know the complication of morphine towards a patient, therefore breach her duty as a nurse. By administering 1 millimeter of morphine to Shan, we can see that Nesdel's conduct was far below the standard of care for a nurse, as nurse needs to intervene appropriately and promptly to prevent complication according to the provisions. The third one is the causation. We must prove both causation, which is causation in fact and causation in law, as we discussed earlier. For the causation in fact, we can use the but-for test to see whether Nesdel's conduct will cause Shan to faint in the toilet. Why we use the but-for test? Because we can see here that it was the primary cause. It was only one causes, not multiple causes. If there is multiple cumulative causes, we need to use the material contribution test in order to prove causation in fact. The effects of morphine was primarily caused Shan's drowsiness and eventually fainted in the toilet. Therefore, causation was established. By looking at the causation in law, we need to see whether Nesdel's administration of morphine to Shan was reasonably foreseeable and will injure Shan. Causation in law does not establish if the defendant's conduct was too remote with the injury suffered by the plaintiff. So we can see here that Nestel and Shan has a close proximity between them because the administration of morphine and Shan fainted in the toilet. This is because if only Nestel didn't give morphine to Shan, Shan would not have fainted. So we can see that there was a close proximity between them, between the defendant's conduct and the plaintiff's injury. So in conclusion, we can say that Nestle was held liable to Shan as all three elements of negligence had been approved, which is duty of care, breach of duty, and causation. However, Nestle might have taken steps to defend herself in the law of tort, such as contributory negligence, which leading to the second issue of the presentation, which is whether the administration of morphine to Shan was a contributory negligence. So, for the rules of contributory negligence, in Malaysia, the law of contributory negligence was applied. According to the case of Kate Kee Leung and Teresa Bonkin, contributory negligence is an expression which means negligence materially contributing to the injury. Negligence here is not used in its usual meaning, not to mean a breach of duty. It was also mentioned in the Civil Law Act 1956, which are Section 12, Subsection 1, where any person suffers damage as the result partly of his own fault and partly of the fault of any other person, a claim in the respect of that damage shall not be defeated by reason of the fault of the person suffering the damage, but the damage recoverable in respect thereof shall be reduced to such extent as the court thinks that just and equitable, having regard to the claimant's share in the responsibility for the damage. So the elements of contributory negligence, which is CN, the first one is plaintiff failed to take reasonable care of himself, unreasonable behavior of the plaintiff with regard to his own safety. The second one is the requirement of causation. The plaintiff's unreasonable act or omission must be a cause of his injury, and the injury must of a type of reasonably foreseeable from his act or omission. In the case of Fu and Yap Hai Chui and others, the plaintiff has extended his arm outside the window while there was a heavy traffic and the defendant suddenly reversed his vehicle from a side lane, collided with the motor taxi and collided with plaintiff and sustained severe injuries on his arm. The court held that the plaintiff had contributory negligence for extending his left arm outside the window, which is 25% to 75%. Muhammad Azmi J stated that when traveling in a motor car along a road where traffic is heavy, whether as a driver or passenger, a person ought to be conscious that it is extremely dangerous even to rest his arm on the door window with or without the elbow protruding. The various police of road users in the city are so common nowadays that they ought to be foreseeable, and a prudent man should, when traveling in such place, keep both his hands well inside his vehicles. So we can see here that the plaintiff's conduct, which is extending his left arm outside the window while there was a heavy traffic, was not unreasonable act to do. Was not reasonable act to do, and he should reasonably foresee that if he extending his left arm outside, there will be a car collided with his left arm. Moving on to the application, to align the rules in this situation, we can see that Shan had failed to take reasonable care of himself, as it is unreasonable for Shan to take morphine even if his pain was unbearable, as it will have bad effects on him. Nesdel's conduct was not the sole cause of him to faint in the toilet, as he willingly wanted to take on morphine, not Nesdel. This is reasonably foreseeable by Shan on the effects of taking morphine to himself, as he was a medical student, and as a medical student, he should know this. By the fact of the scenario, we can see that Shan already proved the contributory negligence made by him, which is the failure to take reasonable care of himself, which is the administration of morphine by himself, by the conduct of himself, and the requirement of causation, which is the reasonably foreseeable, which is the Shan as a medical student, he should know the complication of taking the morphine when he was sick. So in conclusion, we can see that Nursdale and hospital management might defend themselves on the ground of contributory negligence. Contributory negligence might be useful to reduce the liability on the hospital, specifically Nursdale, as Shan was also proved to contribute to the injury that he suffered.
So we go through to the second relevant parties, which is Shan and Dr. Olix, where we identified that there was one general issue, which is whether Dr. Olix could be held liable, although he had learned everything to save Shan. And we identified the three sub-issue, which is firstly, whether Dr. Olix breached his duty of care to Shan by not intervening to save him when a lightning bolt struck and electricity went out. It falls under breach of duty. And secondly, whether Dr. Olix delay in restoring oxygenator during the thunderstorm amounts to brain damage, which is under the causation. And lastly, whether a very bad thunderbolt hit and electricity went off, thus delaying fixing the oxygenator to the generator constitute an act of God, which is falls under defense of torts. So, We go through to the first sub-issue, which is whether Dr. Oli breached his duty of care to Shan by not intervening to save him when a lightning bolt struck and the electricity went out. So, first thing first, we identified the rules, which is first, we use the rules of breach of duty and standard of duty for a professional. As we know that breach of duty is standard of as we know that breach of duty consists a standard of reasonable man, which is factors in which is it consists to factors in determining reasonableness under the practicability of the precaution. And we use the case of Latimer against AEC Limited. As we know that the court held that defendant had done all the a reasonable person, which is prevent the slippery from any injury. Person would do in the circumstances they could not have eliminated the risk completely without closing the factory. It was said that the defendant was liable for the injury by the plaintiff. And secondly, the standard of a duty for a professional, which is as we know that Dr. Olix is a medical staff, and we use the duty of medical professional, and we apply the Bolam and Bolito principle, and we use the case of Boland versus Friend Barnett Hospital Management Committee, where it was held that the doctor follows a protocol that has been accepted by a reasonable and responsible group of professionals with expertise. It was held they are not considered negligent. The defendant in this case was found liable, and by evidence, acknowledged practice, then the doctor knows best theory was upheld. So in applicate the rules, Dr. Ollis didn't breach his duty of care to Shan because he had tried to save Shan after he fainted in the toilet by dragging him to the bed. And he wanted to restore oxygenator. Suddenly, he couldn't because there are a very bad thunderbolt and causing the lack of electricity. Dr. Ollis was struggled to save Shan by fixing the oxygenator, but he failed because there was no electricity and the machine was collapsed. And as we know that Dr. Ollis is a professional medical man, and Dr. Ollis also has followed the guidelines set by the standard of the medical profession. Uh, Although he was not responsible for the fixing the electrical outage um and defended by the Shan. So we go through to the second sub-issue, which is whether Dr. Oli's delay in restoring the oxygenator during the thunderstorm amounts to brain damage, which is fall under the causation. And as we know that causation divided into two, which is causation in fact and causation in law. In causation in fact, we use the but for test, and we not use the material cost test contribution because there was no any binding band effects. So we use the but for test, which is we similarly use the case of Hassan bin Datullah against Kerajaan Malaysia, where the court was satisfied with the initial finding that the injury suffered was not caused by the doctor negligence in the performance of the surgeries, but was the result of the delayed treatment, which is in this case that there was a delayed treatment because of the lack of electricity due to the thunderbolt. Therefore, the claim failed due to absence of causation that we can be similarly to the case. And secondly, under causation in law, we use two principles, which is novus acta intervenis, where the novus acta intervenis can be called as natural event and reasonable foresight test. In novus acta intervenis, which is natural event, we applied the case of Kaslogi Steamship Co. Limited and Royal Norwegian Government. It was said that defender was liable for the damage caused by the storm. The storm was unforeseeable intervening act and unconnected to the defender's negligence. Secondly, the reasonable foresight test. We use the case of Government of Malaysia and against Jumat bin Mahmud and others. It was said at Federal Court that the teacher did not expose to peak injury that was reasonably foreseeable. Further, constant vigilance in the classroom would not have prevented the injury sustained by plaintiff. What must be foreseeable is the type of the damage. The application of the sub-issue 2, it was that no positive proof that showed Dr. Ollis had caused the damage to Shan, as we know in the facts of the scenario. It may have been caused by his own action, which is Shan was removed his oxygen tube himself and went to the toilet. Other than that, it was chain of causation due to intervening event, which is natural event from the bad very thunderbolt, which is it was unforeseeable, which considered as novus acta intervenus. However, the type of damage suffered by Shan was foreseeable due to the lack of oxygen because the oxygenator was not function due to lack of electricity. So we go through to the last sub issue, which is third sub issue, which is whether a very bad thunderbolt hit and electricity went off, thus delaying fixing the oxygenator to the generator constitutes an act of God. Firstly, we look at the rules, which is general defect of torts. We identified that it falls under act of God, which is act of God is unforeseeable and occurs without any human, according to court in Tennant versus Earl of Glasgow. And in order to prove the act of God, we apply to test, which is whether the very bad thunderstorm foresight and rationally may comprehend the possibility of the event occurring, and whether the very bad thunderstorm could have been reasonably anticipated or prevented. We also referred to the case of Nicholas and Masland, where it was had that there was a heavy rainfall, which caused the lake to collapse, and water from the lake swept away for bridges and causing damages. The action was brought that and court held that the defendant was not liable for the negligence because the heavy rainfall reasonably unforeseeable and was an act of God. In applicate the rules, intervening event, which is a very thunderbolt, is an act of God cause the electricity went off, which is beyond expectation as a doctor to face it. Thus, the test for the act of God, which is the force, which resulted the foresight and rationally of an extremely bad thunderstorm could not be comprehend the possibility of its occurrence, and the extremely bad thunderstorm could not have been foreseen and could not reasonably have been prevented. And lastly, the conclusion of all three sub-issues. Firstly, Dr. Oli was not liable for the breach of duty of care because he have tried to save Shan as professional medical man by dragging him to the bed and trying to restore the oxygenator. And secondly, Dr. Oli was also not liable because causation of Shan's action by removing the oxygen tube himself. It was had that an intervening event, which is a very thunderbolt storm, was struck and caused the lack of electricity, which more difficult which are beyond the doctor can be think. And lastly, that also Dr. Ollis was not liable because a very bad thunderbolt storm is an off guard, which is he can use the defense as he can use the air of God as he defends. Where the air of God caused the electricity went off, which is beyond the expectation as a doctor to fix the oxygenator. All right. Now we move to the third relevant parties, which is Mr. Hausen against Mina. So in this case, we have identified the one big issue and three other sub issue to answer the main issue, which is the big issue is uh, whether Nurse Mina is liable for Mr. Hausen broken pelvic bone due to Nurse Mina punching Mr. Hausen as he always disturbing and harassing her. So under this to answer the big issue, we identified three sub-issue, which is the first one, whether Nurse Mina breached her duty of care to Mr. Hausen. Second one is whether Nurse Mina caused the damage suffered by Mr. Hausen. And the third one is whether Nurse Mina can raise her act toward Mr. Hausen as a private defense under self-defense. All right. As now we move to the first issue, which is whether Nurse Mina breached her duty of care towards Mr. Hausen. So we follow and refer to the rules of the standard of care by Nursing Board Malaysia, first edition, to determine whether this minah action is according to the standard of care by a normal nurse. So we have listed three standard of care, which is the first one. Nurse must consciously assesses the physical, psychosocial, and spiritual needs of each patient. Second one, nurse must provide compassionate and competent nursing care to meet each patient needs. And the third one, which is the nurse must intervene appropriately and promptly to prevent complication. We also refer to one case, which is Chin Kiao against government of Malaysia and ANO. So in this case, there was an ama, which is the older Chinese, which woman or man, and the kids go to the clinic to get the injection, or he want to go to the to get the checked by the doctor, and later the doctor give penicillin to the defendant, and after 1 hour the defendant died. uh, but before that is was already written on the patient card that the defendant is allergic to penicillin, yet the doctor did not check it first before he give the penicillin injection to the defendant. So as we can see in this case, what the doctor act which is below the standard of the medical person, because of why he didn't check first the what that written on the patient card, which is the defendant allergic to the penicillin, yet he give it the penicillin anyway. So the act of the doctor is below the standard. uh Alright, so to apply our issue, nurse Mina action by punching Mr. Hausen was far below the standard care of the medical practitioner. Then even though Mr. Hausen always disturbing and harassing her, her response by punching Mr. Hausen is not a manner and a suitable way for a medical practitioner to handle the situation, as Nurse Mina did not achieve the standard of duty of care by a nurse. So Nurse Mina has breached her duty toward Mr. Hausen. So for the second sub issue, which is whether Nurse Mina caused the damage suffered by Mr. Hausen. So it was fall under the causation. So to determine the causation of one party, so we it was divided by two tests, which is the causation in fact and causation in law. So in the causation in fact, we use the but for test because there was only single causes in this fact, and it was not the multiple causes. multiple causes. So we refer to the case of James Kenneth Ng against Lee King Ong. So in this case, the deceased suffer breathing difficulties after the disease suffer breathing difficulties after taking Blocadren, which is a drug that was prescribed by the defendant's doctor. And then the defendant argued that the causation was not proven and not by him. But the disease reaction to the Blocadren was immediate and contraindicated for asthma patient. Why the defendant argued before that because the disease also take other drug other than Blocadren that was prescribed by other doctor, but only the Blocadren after effect that relate to the and contraindicated for the breathing difficulties, which is asthma. And then the court concluded that the Blocadren absent prevented the complication. So in this case, we can see that if the doctor did not give disease the Blocadren, so the disease may still be alive. So in the causation in law, we use the possible test to see whether the if the if the defendant can prove that the effect was the after effect was the which is unforeseeable, so they may be not liable. So we use the case just one sing and send again Central Electricity Board and Arnold. So in this case, the plaintiff dog and 5 buffalo perished as a result of the defendant's negligence in allowing the wire to continue lying on the electric cable for an extended period of time. Uh, then the kind of harm that is anticipated. So in this case, we can see that the act of defendant was negligent because he allowing the wire to continue lying on the electric cable for an extended period of time. So when that thing happened, the defendant can foresee the effect of his act, which is he may bring the damage to the people or anybody nearby, which is in this case it was bring damage to the plaintiff dog and his 5 buffalo. All right, to apply in this issue, for the first one, the but for test, it is satisfied that but for Minah punch, Mr. Hausen would not suffer the broken pelvic bone, which mean if Nurse Minah did not blow his punch to the Mr. Hausen, then Mr. Hausen may not get the broken pelvic bone. There is no intervening event such as like third party that may intervene. The causal link between the Nurse Minah breach of duty, which is her punch that is below the standard of care, and the damage suffered by Mr. Hausen. So for the second one, which is the reasonable foresight test, the damage suffered by Mr. Hausen due to Nurse Minah punches was foreseeable. Why? So, because we can assume that Nurse Minah punch was quite strong, as when Nurse Minah punch give his punch to the Mr. Hausen, Mr. Hausen fell from his bed and then he broke his pelvic bone. So when Nurse Minah do that, she should and can foresee the type of damage that could happen to Mr. Hausen when she land the strong punch on him. Okay, next. Now we move to the last but not least, the third issue, which is the whether Nurse Minah can raise her act toward Mr. Hausen as a private defense falls under the self-defense. So we refer to the case Shafi'i bin Zainal Abidin against Shah Alam OCPD. So in this case, the plaintiff were chased by the police officer and shot by them after a collision. The court acknowledged the defendant fear of harm and deemed the shooting appropriate given the close distance by him. So we can see that even though the defendant, which is a police officer, shot the defendant, but it was acknowledged by the court because it was defendant have fear of harm because the act of the plaintiff, which is they will their long knife, or we call it parang, towards them. So it gives them the fear of harm, because the distance between them was so close. So to apply in this issue, Nesmina claim of self-defense was not supported by any reasonable fear of harm, which is we can say that the referred case was distinguished and contradicted by application. So if the Mr. Hausen action didn't bring any fear of harm toward Nesmina, so we can say that Nesmina cannot claim for the private defense under the self-defense, because in addition we can say that as it happened to every nurse he had ever met, his behavior was not directed towards Nesmina specifically, which means the Mr. Hausen act to which is harassing Nesmina was not solely intended to bring harm toward Nesmina. So for the conclusion, to answer the big issue is whether Nesmina is liable for Mr. Hausen broken pelvic bone due to Nesmina punching Mr. Hausen as he always disturbing and harassing her. So the answer is yes, Nesmina is liable. As for the answer before, which is the first one, Nesmina is has already breached her duty towards Mr. Hausen, as the act of Nesmina punching Mr. Hausen was so far below the standard of care by a reasonable nurse. And the second one, which is the Nesmina punches, was the solely and only cause towards the damage suffered by the Mr. Hausen, which is he get the broken pelvic bone. Even though Nesmina want to raise the self-defense, he cannot do that because the act of harassing by Mr. Hausen was not bring any reasonable harms toward Nesmina. So we move to the sub-element, which is the first one is protection of life, which it gives in us. And we refer to the Surah Al-Baqarah, verse 195. The meaning of the surah, this verse, which is, and spend in the way of Allah, and do not throw yourself with your own hands into the destruction by refraining, and do good indeed. Allah loves the doers of good. So how can we refer to this case? Which is we as a human, of course, we must not do anything that may bring us toward the destruction or any harm. Like maybe in this case, what was do by the Shan, which is he was pretend to know everything, and he like being know more thing than the medical practitioner itself. So when he do that, it's already bring harm to him. So for the second one, which is amanah, falls under the we use the ayah, which is Auzubillahi. Ya ayyuhalladzina amanu la takhunullah wa rasul wa takhunu amanatikum wa antum ta'lamun. It means, O believers, do not betray Allah and the messenger, nor betray your trust knowingly. So as we know, amanah is the one of the most important element in our life, and also in the person that already work. So we as a Muslim must always bring amanah in our work, so that our work will be more efficient, and we will not being against the our responsibility as the Muslim towards Allah Subhanahu wa Ta'ala. So I think that's all from three of us. I hope all of you enjoy and understand about what was mentioned in this video. So good luck for final test to all of you. Thank you.